A very fine good evening to all the participants here in this session. Myself, Uttara, second year LLB student, Mar Gregorius College of Law. This is our third session in the topic Arbitration Practice in Law. It aims to induct those law students who are interested in pursuing arbitration in law as a career. Today, we are here to have a discussion on the topic Arbitration Agreement and Constitution of Tribunal, conducted by LJRF in association with Cochin Institute of International Arbitration. I wholeheartedly welcome you all to this session. I now invite Ms. Amina to officially welcome us all to today's session.
Thank you, Tara. Good evening to one and all. Myself, Amina SM. I am here to extend my warm welcome to each and every person who are assembled in this session, much informative session. As we know, this is our third session on arbitration, where Cochin Institute of International Arbitration and Law and Justice Research Foundation Tribunal chapter constitutes to make it special, and it is special. As we got a phenomenal speaker today, Mr. Anish Wadia, an experienced lawyer with full rights of audience before courts in India and solicitor as many more countries. I extend my welcome to you, sir, and we must feel gratitude for having him because he is the youngest appointed Pan-India member of the Investor Grievances Redressal Committee of Mumbai. I'm sure that we can imbibe something from your thoughts, sir. Next, I would like to welcome Advocate Johnson Gomez, sir, a person who are very eloquent with his opinions. Thank you and a warm welcome to you, sir. Next, I would like to welcome the most warm person, Mr. Safi Mohan, sir. I must appreciate much initiative effort that he makes. Now, I welcome Sri Lakshmi for reviewing our previous session. Welcome, dear. I must welcome our coordinating forces, a truly hardworking members, Nilima V. Nair and Advocate Sunita S. Very warm welcome. Last but not the least, I welcome all the participants, and I truly believe that the session is going to be fruitful as same as the previous session. Thank you.
Thank you so much, Amina. Before we move on to our today's session, it would be indeed fruitful to recollect what we have discussed and learned in our previous session. For that, I now invite Ms. Sri Lakshmi to give a brief appraisal about our previous session. Sri Lakshmi, are you there?
Yes. Good evening to all. Today I am here to give a summary of our second session, which was delivered by Sir Imbavijayan Veeraraghavan about arbitration process, a general overview. In the session, we discussed significantly about arbitration agreement, commencement of arbitral proceedings, composition of arbitral tribunal, competence of arbitral tribunal to roll on its jurisdiction, conduct of arbitral proceedings, making of arbitral award and termination of proceedings, etc. A party's right to transfer, refer a dispute to arbitration depends on the existence of an arbitral agreement, the arbitration agreement, between them and the other parties to the dispute, that the dispute may be referred to arbitration. Commercial contracts will commonly include the provision for how dispute relating to that contracts are to be resolved. The parties choose arbitration. The arbitration agreement will generally be part of the document recording the terms of the commercial transaction. In entering into an arbitration agreement, the parties agree to refer their dispute to a neutral tribunal to decide their rights and obligations. Although sometimes described as a form of alternative dispute resolution, arbitration is not the same as that of mediation or conciliation. It's a quasi-judicial process. Then, as a things or factors to ponder, the session also discussed about the party autonomy and intervention of courts, then principle of natural justice, that is equal treatment of parties and arbitration processes, arbitration as a user-friendly process guided by law, but gives the parties to agree on the procedures. Then demand under complaint, cause of action and limitations, dispute resolution clause or jurisdiction clause, arbitration clause, etc. And also about the perspectives of courts and challenges with respect to party autonomy and the impediments, which described in sections 12, 13, Schedule 5, 6, and 7 of Arbitration Conciliation Act 1996, etc. The arbitration agreement will determine key elements of the process, Will the tribunal comprise one person or three? How will the arbitrators be selected? Where will the arbitration take place? And where will the legal seat or place of the arbitration be? And will the arbitration be conducted in accordance with the rules of a particular arbitration institution, or will it be ad hoc? All these factors can have a significant effect on the time and cost of the arbitration. There may be steps set out in the contract which have to be followed before you can start arbitration. A claimant will typically start arbitration by sending a document known as a request for arbitration or notice to arbitrate to its opponent. If your arbitration is to be conducted in accordance with the rules of a particular arbitration institution, that institution's rules will typically prescribe what should be in your notice to arbitrate. Also, if the arbitration agreement stipulates that a disputing party should nominate an arbitrator, the notice should include the identity of the individual the claimant wishes to select. The other party will then have the opportunity to respond briefly within a set period of time, and then the tribunal must be formally constituted, the issues for determination must be identified, and processes and timetable must be decided. Then about the conduct of arbitration. It will then proceed in accordance with the procedure that has been adopted. It is likely to include each party producing written submissions, will be also with part of the written witness statements and the reports of technical experts where appropriate. Then about the arbitration hearing. It can last from half a day to many weeks or even months, depending on the issues at stake. Then sessions also discussed in further about the cost, time, normal procedures, enforcement, and other related advantages. Time frame given and arbitration facilities, clarification, testimony of evidence, oral submissions and closing submissions in relation to fast track procedures and oral hearings, its relevance and advantages, and also about the administrative assistance, choice of parties to select ad hoc or institutional arbitration, fixing the language, what documents has to be produced, and what is the prior statement of claims and significance of words in arbitration, then conduct of hearing, inviting parties, and communication processes are other factors which we discussed in detail. Also about the 2015 amendment of Arbitration Conciliation Act 1996 for all arbitrations commenced on or after 23 October 2015 and about the recent amendments in 2019. The Arbitration Act is largely based on the unsettled model law. There are, however, some significant departures which make it difficult to supply the model law jurisprudence directly to each case. The Act contains a number of mandatory provisions, including relation to requirements for the form of arbitration agreement, mandatory provisions or mandatory reference to arbitration by courts, grounds of presumed impartiality and lack of independence, time limits for completing arbitration proceedings, grounds for setting aside an arbitral award and termination of proceedings and other related things with respect to pleading, etc. After the hearing, the tribunal will produce its award. This will set out the decisions it was reached on the issues between the parties. Unless the award is challenged, it determines the rights and obligations of the parties challenging or appealing the award, varying depending on factors such as the terms of arbitration agreement, the arbitral seat, and the institutional rules. A tribunal's findings of fact can rarely be challenged. And then enforcement. The realities of enforcement vary depending on the factors such as the jurisdiction in which enforcement is likely to be sought, the status of the party against whom enforcement is sought, whether it is possible to take steps to ensure the other side does not get rid of its assets to frustrate enforcement. Most government entities and public sector undertakings include arbitration clauses in their standard form contracts and are regularly parties to arbitrations. Also, there have been a number of recent moves to improve the arbitration landscape in India. Significantly, amendments to the Arbitration Act have sought to improve speed and efficiency of arbitration by imposing time limits, encouraging institutional arbitration, reducing the scope for court intervention, discouraging filing frivolous applications challenging arbitral awards, and discouraging delays by introducing a most realistic cost regime. Also, we discussed about the Part 1 of the Arbitration Act, which deals with the arbitration seated in India, and Part 2, which deals with arbitration seated outside India. Here, certain provisions of Part 1 of the Act, such as the court assistance in aid of arbitration, also apply to the arbitrations seated in outside India. The session in detail spoke about the requirement for an arbitration agreement to be enforceable, such as by on documents signed by the parties, an exchange of the correspondence which provides a record of agreement, an exchange of statements of claim and defense containing an undisputed acknowledgement of the agreement. A third party is not normally permitted to be joined to the arbitration proceedings except where the third party is a person claiming through or under a party to the arbitration agreement. And when an arbitration is in breach of a valid jurisdiction clause, the aggrieved party can raise a preliminary objection before the arbitral tribunal.
Can I interfere? Can I interfere for a moment?
Yes, sir.
Srilakshmi, I think that many of the things that you are now discussing was outside the scope of what was stated by Mr. Imba Vijayan last time. We need to keep a track on what is stated by the speaker. And we are not supposed to go to the text and get information for the review. We need to just follow this speaker. And I think that last time also I was trying to remind it, because we are not interested in the textual informations that are available. We are only interested in what was stated. So try to focus on that, enumerate that. Maybe 10 points were stated by them. Try to recollect the 10 points. Our exercise would be only for that purpose. Okay, you may complete, but this is the method that we wish to follow, because this will confuse the people, other participants, because I was also a little confused as to whether these things were discussed last time, because you have gone to part 1, 2 and all those things. We have just gone to a few points that was discussed, and it was within that framework that we have talked. So always track the speaker. That is our job. Okay, you may complete it.
Yes, sir. Okay, sir. Then we further discussed about the Supreme Court judgments, which has confirmed that Indian courts have the power to grant an injunction to restrain proceedings started overseas in breach of an arbitration agreement where the proceedings are found to be oppressive and vexatious. And also, in granting such an injunction, the court will be guided by factors such as committee of courts, mandatory language of the arbitration clause, and so on. Then about the commencement of arbitral proceedings, applicable rules and powers, evidence and disclosure, confidentiality, relevance of sections 90, 21, 23, and 25, etc. Also discuss the provisions under section 6, 9, 11, 16, and 18 to 31 and 33 of the Arbitration Conciliation Act 1996, including reference to disputes to arbitration, granting interim aids measures in aid of arbitration, appointing arbitrators, hearing appeals from certain decisions of the arbitral tribunal, etc. An arbitral proceeding must be completed within 12 months, and the particular provision, section 33 of the amended Act of 2019 also discussed. Capacity of parties, validity of the arbitration agreement, appointment and jurisdiction of the tribunal, procedure for conduct of proceedings, arbitrability of disputes, and conflict the public policy of India are also major points. Then discussed about the provisions which included in the same, that is interim remedies and ex parte, as a brief description. Then final remedies from the tribunal and enforcement of an award, length of the enforcement proceedings, and about the recent amendments, Supreme Court judgments, etc. And then finally, the question and answer session, we also discussed briefly about e-port transaction and e-commerce contracts and how it will work in the arbitration agreements, proceedings, and in making award, etc. The session is very informative and it contains a lot of information which I just briefly explained here. So hope you got an understanding of the same. Thank you.
Thank you so much, Srilakshmi. Now, I am indeed delighted and honored to have with us our most respected speaker of the day, Sri Anish Wadia, Pathway Leader and Course Director of Chartered Institute of Arbitrators, United Kingdom. And we are very much pleased to have you with us today, sir. And we also have with us Sri Johnson Gomez sir, Director, Cochin Institute of International Arbitration, who has been there with us as a strong pillar of encouragement, and he was enlightening us all through our past 2 sessions with his knowledge and ideas. I wholeheartedly welcome you both to our today's session, and I also invite Johnson sir to proceed with the session. Hello, sir.
Thank you very much, Uthara. Yes, I think maybe you may have some audio difficulty. We'll wait for Johnson.
Thank you, Uttara, and thank you, Sri Lakshmi. I just want to, I will just take 1 minute before I leave this Anish Wadia sir to take up. We have talked about 3 concepts, 3 general principles of arbitration in our first session. That is based on the under section 1 of the English Arbitration Act. And we have taken a very general view about the arbitration process, and that was discussed by Mr. Imba Vijayan. That included these processes as commencement, appointment, and so on, and how the process travels. It was just to give an idea to the participants as to how the process works. Now, this session is actually intended to give a detailed insight about a little more detailed insight about arbitration agreement. And when I had to interfere with Sri Lakshmi, because here we are looking for a very systematic process of study where we have not studied anything in detail. And let other participants also be informed that we had just a very bare idea about what arbitration is. And we don't want a textual study at all. We just want to follow the speakers. They are very experienced people, and while we report the speaker, we should keep in mind that we will mention it is just for the recollection. It's just for the recollection. He might have 10, 15 points. Try to identify those 15 points that were mentioned by the speaker. You don't go to the text. You don't go to any judgments. You don't go to any books. We will learn the books and all a little later. We will give you good assignments. You will be doing all those things. A lot of exercises will happen a little later. Now this is to give you an idea, and you just follow the speaker. And that is the important thing. As of now, I would only want to say that we are on the very preliminary stages. And let us go in detail as to what is an agreement, what is a pathological clauses contained, normal pathological clauses that are found in arbitration agreement, and how an arbitration tribunal is constituted. These are the 3 concepts that we will be discussing today. And we will go by concepts. We don't go by books. We don't go by judgments. We don't want a lot of information. We want to limit our information. That is my concern. So try to do that while we report next time. Thank you. I leave to Mr. Anish.
Thank you very much, Johnson Gomez, for inviting me, and of course to the organizers, the Cochin Institute of Arbitrators, and the college for having me here today. It's indeed exciting, and thank you all for the introduction. I very much appreciate it. And just a slight correction: I'm no longer with the Investor Grievance Committee. I act as a full-time arbitrator. That was from about 2016. But that being said, and I'm very glad what your facilitator over here, Mr. Johnson Gomez, has said, in that today, many a times in several webinars or training sessions, the focus tends to be a lot on theory. And I think often at times the disconnect that exists when each of you are interning at law firms or once you graduate, is being able to bridge that gap between what you've studied and what actually transpires in everyday practice. Often at times, that's why we often find that many Indian law students, though exceptionally brilliant, and some of them do very well in the final examinations, you have a situation where they do not succeed in their in opportunities at either a tier one law firm or working in an overseas environment, because students from, let's say, international universities have a greater focus on practice, on practical application than theory. So I'm very glad to see this endeavor by the college and the Cochin Institute of Arbitrators to bring about and stress on the importance, like Mr. Johnson Gomez has just said, on practice, on practicality over theory. And that's what I shall seek to do and I'm going to break it down in as simple as possible. And please keep in mind, I know all of you are here today studying to be lawyers, and I'm sure Johnson will agree with me when I say that, us lawyers love making things very complicated. It's ingrained in our old school training, and I think I'm very glad when Johnson Gomez said that, look, let's focus on practical aspects, and I'm stressing on this because what that will do is, and the goal being in such a session today, that when you're interning at a law firm, I do not want each of you, when you're acting as interns, to blindly be mechanical robots following what someone is doing or what someone's asked you to do. Apply your mind. That's why you sometimes have individuals who may be younger than the fourth-year law students and who still get PPOs in their second or third year, because they've taken that courage to apply their mind. Just because someone senior in the profession is saying something, ask it, how you put it across, those soft skills. That's part of the process of what you learn, and throughout these lectures, I'm sure Mr. Johnson Gomez will convey those to you. So that's the objective and the perspective from which I'll be speaking to you today. Now, the scope of my session for today, and I'd like to keep it as brief as possible because I'd rather open up the floor to practical questions, because I'm sure many of you have interned in law firms and have seen certain things which, especially in the arbitration process, which may not make a lot of sense to you, but which there are more efficient and streamlined ways of handling those. So my scope today is talking about the arbitration agreement itself, issues of pathological clauses, where it all started, and of course, talking about the composition of the arbitral tribunal, things to keep in mind, and the difference between doing so in an ad hoc manner and a institutional appointment mechanism. Now, before I start off with that, I'd like to first cover an essential ingredients of what goes into an arbitration clause. And the big issue that revolves around this, and one of the biggest concerns, is use of terminology such as place, seat, interchangeably. Oftentimes, for example, there are many institutional rules which don't use the word seat, but in place of the word seat, they use the word place, okay, which signifies the seat. Now, what happens is, and this is one of the points to keep in mind, and this is what I believe was covered in your previous sessions, that today, when you're preparing an arbitration agreement, and as each of you have already are aware, an arbitration, whether you call it a clause or an agreement, it's applying the doctrine of separability. Even if your underlying or the main contract in itself is void, your arbitration agreement still survives, okay? And therefore, it is important when drafting an arbitration agreement that it's prepared in an all-encompassing manner with no room for any ambiguity whatsoever. Now, generally in India, the vast majority of arbitrations tend to have been ad hoc, about 90-odd%. And in the institutional context, the chances for there being pathological clauses in an arbitration are very rare. And I'll talk about what started the big discussion in pathological clauses was a 2009 decision of the Singapore Court of Appeal, which we'll come to shortly. But before I get to that, so that you understand the issues, I want to explain the issues from an ad hoc context, keeping in mind what is prevalent in India and what many of you may experience or face when dealing with arbitrations when you're interning with law firms. Now, the first and most important thing to keep in mind when, let's say, you're drafting an arbitration clause, while some jurisdictions accept the words place as meaning juridical seat, you need to also understand that, let's say, for example, and I've seen this happen many a times, where the arbitration agreement uses the word place, and wherever the relevant place is, let's say Mumbai, or let's say Paris, is fine, perfectly enforceable. The courts which have supervisory jurisdiction, which we've learned in the earlier sessions, will find that perfectly fine, no issue whatsoever. Where the issues may arise, okay, is if in the jurisdiction of enforcement, okay, let's say for example the Shanghai court, or or the court in Beijing, how do they interpret the word place? Because you also need to remember, in jurisdictions such as China, they very rarely, and as a rule of thumb, enforcing an award passed by a non-Chinese arbitral institution is not an easy feat. Even small technical matters such as this, and using that as the basis, the award can be, the enforcement can be refused or set aside on very minor technical aspects. And I'll give you another SIAC example, which is a Singapore International Arbitration Award, which was very recently, I think sometime this year or earlier this year or late 2019, where an award perfectly enforceable on merit, so the Singapore International Arbitration Center, was sought to be enforced in China, and that enforcement was refused. This was earlier this year, yes. I think around maybe January or February this year. The enforcement was refused on the ground that the arbitration clause said 3 arbitrators, okay? However, the arbitration clause said in accordance with the Singapore International Arbitration Center rules, okay? Now, if people may wonder, okay, what's the issue over here? This seems fairly straightforward. Now, in this context, and there was nothing about, the clause was very standard, it was the standard SIAC arbitration clause. However, and this is where bad lawyering is very evident, all institution rules have something known as opt-out provisions as well. For example, the ICC rules, or the ICC is the International Chamber of Commerce's Court of Arbitration rules. The most recent version being the 2017 version, which has, there's a new amended version which will be launched, which is a 2021 ICC rules. It's being officially launched on the 1st of December. The final version of which will be released on the 1st of December. Right now, the draft version is available online to view. And those new 2021 ICC rules will be effective from the 1st of January 2021. It's a very interesting to read those rules. Now, all rules, whether the ICC, the SIAC, the Hong Kong International Center, etc., they have some provisions called opt-out, which involves perhaps to do with, I'll give one easy example, expedited procedure arbitrations. And what does it mean to say opt-out? Where parties in the arbitration agreement itself must stipulate, even when you're citing the Singapore International Arbitration Center rules or the ICC rules, must clearly stipulate that the parties opt out of article so-and-so dealing with expedited procedure. Now, what does that mean when a parties opt out? It means that what the ICC rules or the SIAC rules state is that even if you've put 3 arbitrators or a panel of 3 arbitrators, okay, the clause states this, under the ICC rules, the matter, a case will go into expedited procedure, which means only sole arbitrator. A lot of the other long-winded mechanisms of procedure under the relevant institutional rules will no longer be applicable. If a dispute is under, for example, under the ICC rules, it's $2 million US. Under the SIAC rules, if I'm not mistaken, it is 3 million Singapore dollars, which is more or less equivalent to about $2 million US. So what happened in this case that I spoke about in China, the award absolutely sound on merits, on on the governing law, all of that. The reason, and the sole reason it was set aside, was because whoever drafted the arbitration agreement did not stipulate that that we opt out of the expedited procedure provisions. Okay, simply said SIAC rules. So the Shanghai, and because the dispute in value is less than about 3 million Singapore dollars, the SIAC said no need for 3 arbitrators, only a sole arbitrator will be appointed. So the courts in China said, sorry, the arbitration agreement said this, whatever the parties have agreed to in writing, that is squarely applicable on the case at hand. Okay, and this was an issue. Now, even after, let us say, someone bad had drafted this arbitration clause a few years ago before the matter went into dispute. Now, what the parties to lawyers ought to have done, keeping in mind the importance of potential enforcement issues, is have entered into a simple half-a-page agreement signed by both parties saying the parties, in pursuance of the arbitration agreement contained in so-and-so contract, vary it to the extent that we are opting out of the expedited procedure provisions, etc. All they had to do was execute in writing. They never did. The parties may have accorded their consent, but under Chinese law, it has to be in writing. And there was no formal technical requirement in that respect. Now, all of you know, in most jurisdictions, this would never have been the case. It would have been absolutely enforceable, no issues. But the parties did not keep in mind issues and concerns at the potential jurisdiction of enforcement. Therefore, what I'd like to talk about is certain essential ingredients to be contained in an arbitration agreement before we go into discussing some potential pathological clauses. Okay? And we'll talk about the infamous Insignia case in this regard in 2009. Now, the first and the most important thing to always specify in an arbitration agreement is the juridical seat. Now, you may think, oh, why is he using the word juridical seat? We normally don't hear this term. We normally hear the term seat or place. The reason I say juridical seat, because ask yourself this. Do you want to use a word which may have absolutely zero room for misconception or being incorrectly construed in any manner whatsoever? And that word would be juridical seat. Now, what I like to always do when you're writing, say, juridical seat, okay, especially perhaps in an examination context or when you're undergoing training, put in brackets its relevant Latin term called lex loci arbitri, okay? Now, let's say, for example, some of you may intern under an arbitrator, okay, as their tribunal secretary. And let's say this arbitrator is doing, for example, an arbitration under the ICC rules. Now, the ICC rules utilize the word place. And when the award is being scrutinized by the ICC court, they will not like you using the word seat. Because when wherever you're signing your signature, either as a sole arbitrator or on a panel of 3, they want you to write the word date and they want you to write the word place. Now, you may think, I don't like writing this word place, it may cause issues, etc. Very simple solution around that. In your award, what you can advise or guide the arbitrator under whom you intern is put a definitions clause. And in that definition clause, say something like, as defined, so write the word place, colon, and this is how you would define the word place. As defined under the rules, and then you mention of the ICC, SIAC, put the full form, and as used in this document, and this document could be the final award or procedural order number 1, 2, etc., means the juridical seat, brackets, lex loci arbitri of this arbitration. When you put the definition across in this manner, there leaves zero room scope for any ambiguity or whatsoever. So then you can use the word place. Because when you use the word place, when place is being defined in that relevant document, you leave no room for any scope or misinterpretation in jurisdictions like China or in many other smaller, non-arbitration friendly jurisdictions in some remote parts of the northern part of the African continent, etc. It's important to keep this in mind. Okay, now, when you do this, and the importance to do this, I'll come to later, is you need to keep in mind the cross-border nature of international arbitration today. It is therefore imperative to utilize universally acceptable terminology, since the same award may need to be enforced in more than one jurisdiction. Because today, let's say the winning party has an award of 150 million US dollars, and let's say the assets at the seat of the losing party to recover are only 20 million. Another 40 million are in country B, another 30 million in country C, D, so on and so forth. So that same award will need to be enforced in multiple jurisdictions. So therefore, and coming to and this part I'll cover on the importance of who you appoint as a tribunal. It's important today that your arbitrators appreciate the aspect of making your award enforceable, not only from the perspective of the seat of the governing law, but also the jurisdiction of enforcement. It's very, very important. And I'll give you a few examples when we come to the rest of the session, in the latter half of the session. So that covers the issue of juridical seat. And another important perspective to keep in mind is different jurisdictions across the globe have different systems of law, how court hierarchy, and different legal cultures. And each of them interpret and view aspects such as public policy either very in a restricted manner, very broadly. Even sometimes within the same jurisdiction, public policy may be interpreted in a different manner. So therefore, it's important, always important, that you clarify the juridical seat. And I'll give you one example. Many years ago, when I was working at one of my previous places of employ, I had one of the corporate partners, give me a call one day, and I've been a disputes lawyer all my life, and said, "Oh, Anish, how's it going? Blah blah blah. Oh, we've just negotiated a complex shareholder agreement, and we want to quickly insert some arbitration clause, and we want to put the seat as Japan. Any issues?" I said, no issues per se, but I said, why are you asking me this question? No, you're from our disputes team, you've done a lot of arbitrations. I said, yes, but if you want to put Japan as the seat of the arbitration, you need to speak to a Japanese lawyer. So why Japanese lawyer? Then I said, before I answer that question, I asked another question. I said, why do you want to select Japan? Out of curiosity, both parties are, in one party is from India, one party is from Japan. Why wouldn't you want to select, if your client is from India, why wouldn't you want to select a closer jurisdiction? Like Singapore? No, our CEO of our client has just recently bought a house there in Japan. So if there is an arbitration, he wants to be able to stay there. And it's a big mansion, so he can save costs, etc. This legal team, they can all stay there. I said, very interesting. I said, but do you understand the implication of the word seat? Because when you insert a seat, and when you specify the seat, that court of the seat will have supervisory jurisdiction, as you've covered in the earlier sessions, for that arbitration. When it comes to certain interim measures, or whether it be an interim application that may need to go to court, or in terms of during the pendency of the arbitration, where let's say an arbitrator may need to be replaced in the ad hoc context, it's not an institutional mechanism, so on and so forth. So that got them thinking. So therefore, another important point to keep in mind today, your arbitration agreement in the entire contract is the most important provision. Today, some of you may not wish to become disputes lawyers. You may decide to become corporate lawyers. But please use what you learn in these practical series of training. That when you're acting as a corporate lawyer, a draftsman, a solicitor, whatever terminology you seek to use, please make sure that you apply your mind from the mind of a disputes lawyer and what you're learning today. Okay? You cannot leave the arbitration agreement right for the end power and put in something like, I want to select Japan because the client has a house there. I mean, what's the logic? You need to ask, okay, how do courts view, and this was a very high value shareholder agreement, and one of the biggest concerns, and that was the IP, the intellectual property. I said, no one, and you need to solicit the advice, the legal advice of a Japanese lawyer who understands, okay, is this a better seat to choose and why? How do courts view, are they easy in giving interim protections? What is the scope of the interim protections that can be given by a tribunal in a particular seat as opposed to a court? These are questions that need to be asked, and very pertinent questions when you're drafting your arbitration clause. So remember, first, juridical seat, which must be classified as lex loci arbitri. And also remember that in some jurisdictions, this may be known as the place. And please keep in mind that in India, there's been such a plethora of judgments swinging from left and right, where sometimes the word place is interpreted as venue, and sometimes the word place is interpreted as seat. These are concerns that, though to a certain degree was clarified in Balco subsequent judicial precedent have just made things all the more confusing, though the Bharko decision was a constitution bench judgment. It's just, it makes India less in such type of conflicting views on how place and seat are interpreted, make India less investor perspective friendly. Okay. Now, what else should we specify in the arbitration agreement? Very important to specify venue. Now, some of you may think, okay, look, pursuant to the entire new way of thinking that the COVID-19 pandemic has brought with us, the whole term of venue has a different meaning altogether. But it's still important to define the term venue in the arbitration. Now, let's say, for example, if venue were to be defined in the arbitration clause, keeping in mind that you want physical hearings, you say the venue of the arbitration could be something like the geographical physical location where hearings/meetings of this arbitration shall take place. Okay, so therefore there will never be any ambiguity. However, let's say if parties want to make it clear in terms of virtual hearings, you can say the hearings. Let's say after this, the parties may mutually agree that they want to conduct the hearings virtually. Then in the procedural order and in the final award that's issued by the tribunal, it must be made clear, and submission should be made to the tribunal, that requesting them to please define venue from an enforcement perspective, to say something like venue so-and-so was, the hearings in this arbitration took place online virtually using Zoom, WebEx, Google Meet, etc., video conferencing platform. And that is how the venue would be defined. Now, what do you do in a situation, and this happened where, and this created some issues in enforcement, where the tribunal did not specify and define the term venue. And in this particular arbitration, a colleague of mine who was an arbitrator in this case was narrating this to me sometime last year when I was in Hong Kong. And they said, Anish, it was very interesting and we perhaps should have done it. And I was just speaking to him about, one of these lectures I was giving and how I like to always specify this. He says, oh, what they did was, in that arbitration, they had 5 different venues because parties were from all over, and to make sure that the costs were balanced. We had one venue in Austria, one venue in Paris, one in London, and these were all physical places for the hearing. Okay. What one of the losing party alleged that, and each of these were at key stages. So one hearing was in relation to preliminary issues, was in Austria, in relation to issue number 2 was in London, Paris was issue number 1, etc., etc. And what the losing party sought to cheekily do, and the matter was still pending at that time, but I didn't follow what the outcome of how the enforcement court finally decided on this. But what the argument the losing party said was, oh, each of these locations was a seat because parties by consent agreed that this would be the seat, and therefore this particular court has no jurisdiction, etc., to entertain a challenge to the award in relation to this issue, because this issue, the seat was decided as that. That issue, the seat was decided as that. Now look at the mess that was created simply because an arbitral tribunal did not put one sentence. Just one sentence was needed. And even if the tribunal did not do that, it is the responsibility of the lawyers, the parties, to make that submission. Say we request, and this is what the parties agree, that we request the tribunal to please define the word venue to mean this, to ensure that there are no issues from an enforcement perspective. Simple. It's that simple. Okay, so again, please specify the word venue. Now, while dealing with an arbitration, you will come across the term law of the contract, which will be the governing law of the contract, which may or may not be the same as an arbitration clause. For example, many a times in shareholder agreements, which some of you may or may not have seen, you will find, especially when you're dealing with investment by a foreign party, parties tend to choose the governing law of the contract as English law, but the law of the arbitration may be Indian law. Okay, they can be different. So keep that in mind. Now, sometimes you may hear the term proper law, get confused. So what is proper law? Oh gosh, this is a funny new term. I'm very confused. No, don't be. The word law of the contract, the term law of the contract, governing law of the contract, proper law of the contract, and substantive law of the contract are all the same. Substantive law, proper law, and law of the contract are interchangeable terms. It's just that people in different jurisdictions and different cultures use a different terminology. So again, when you're drafting an arbitration agreement, though it is not necessary to do so, it is always advisable to clarify, okay, when you're drafting the not only the arbitration agreement, but when you're drafting your contract itself, make sure it specifies the law of the contract / proper law / substantive law is the law of England and Wales. Okay, and please also remember and understand, there is no such thing as the law of the United Kingdom or the law of the UK. Okay, the United Kingdom as such is not a country. It is, as the name defines, a united, like the United States of America, it's a united group of countries, because England and Wales, the legal system operates differently from Scotland, Ireland, etc. Example, in England and Wales, the concept of champity and maintenance no longer apply. They were abolished long time ago. Whereas in Scotland, it still does apply. As recently as a 2017 Supreme Court decision in Scotland still holds that the concepts of champity maintenance apply. Whereas in India, again, it does not. Even in India, the concept of champity maintenance have ceased to exist in 1872, which position was reaffirmed by a constitution bench of the Supreme Court in 1953. But anyway, I digress. But again, important to be crystal clear. So I'll repeat. Law of the contract is the same as governing law of the contract, proper law, and substantive law. So always specify these and put them as law of the contract, brackets also known as proper law / substantive law. Makes matters crystal clear. Now, procedural law. Okay, now what does procedural law mean? Procedural law talks about the procedure for the conduct of the arbitration. Because see, today, you may say the substantive law, and I'm talking again from an ad hoc context. You may say that the substantive law is, let's say, Indian law, both from the law of the contract and the Indian Arbitration Act applies. You know, seat of the arbitration is India, is Mumbai. Okay. Now, what would be the procedural law? Because the Indian Arbitration Act does not talk about procedure. Okay, it just mentions certain mechanisms. It does not talk about, you know, timelines or how much time should be given for cross-examination, etc. It doesn't talk about a lot of that. Okay, because parties are free in an ad hoc arbitration to decide the procedure. Okay, or the arbitral tribunal is free to decide in the absence of an agreement from the parties. So procedural law, as the name suggests, is a set of procedures that govern the conduct of an arbitration. Now, in an ad hoc arbitration, a tribunal is free to decide on that procedure, but I am absolutely dead against, okay, unless you know that the tribunal you have appointed is a very experienced arbitrator. Now, by experience, I don't necessarily mean experience by a nature of the number of gray hairs the person has, okay? I mean, yes, they may be very well experienced, but by experience, I mean experience in international best practices. And I'll give you one example in procedure, which I'm sorry to say is utter and absolute irrelevant and nonsensical in the Indian context, and I'll say this unequivocally, is this whole concept of statement of admission and denials and marking of documents. Okay, and I want to focus on this for a moment, so that today, because I am fairly certain at some point, each of you, when you're interning at law firms, you will be asked to prepare a statement of admission and denial of documents, and you'll be asked to, a hearing will be fixed for marking of documents. An utter waste of time, money, energy, resources in an arbitration. Most importantly, a waste of time and money for the parties. Okay, and why? What is a statement of admission denial? That, oh, I have to admit this document, I have to deny this document. It's nonsensical, because whether or not you make that statement, a party, whether they admit or deny it, still has to prove their case at the stage of the evidence. Okay, so if they don't prove their case, whether you've admitted it there or denied it there, has zero consequence. What matters is what you can prove or not prove. So having this nonsensical stage in an arbitration, oh, I'll exchange another 2 weeks of filing a statement of admission in denial of documents, 2 weeks, for what? Utter nonsense. Okay, no need. Marking of documents. So we need to mark this document as this. Why? An easy way to resolve this whole concept of marking of documents is in your first procedural order that the tribunal issues, you should clearly state that when you're filing your pleadings, make sure you file your pleadings. For example, let's say the claimant, there'll be certain core contractual documents. The claimant and the respondent are to agree on what is known as an agreed bundle of documents. Core contracts, let that form one bundle of documents. Okay, then whatever else, then that will have one reference that all parties will use. Whatever the claimant is referring to, exhibit C1, C2, C3, rather than the respondent attaching those same documents that they need to refer to, which is pointless and nonsensical, you simply refer as annexed in exhibit C1. Simple. What is this duplication? What is that to mark? The only time a marking comes into question is when, for example, during the course of cross-examination or during the course of examination chief or final arguments, a party tenders a new document, or let's say a case law. Normally you never mark case law and evidence, but let's say, for example, a party tenders a chart, okay, and gives it to the other side, you mark that on record, and you can do that at the stage of cross-examination. You don't need to hold a separate hearing or a sitting for that. Waste of time and resources. Therefore, coming back to when I was talking about procedural law, today it is so important to specify that in an arbitration. Because today you do not, this whole tendency in India to appoint individuals belonging to a certain profession is not bad. It's just that you need to appoint a person, and even if they belong to a certain profession which I shan't name, that doesn't make them de facto untouchable, but you need to appoint someone not because they held a certain office before, appoint them because they've been adequately trained in best practices. Just because a person belongs to a certain vocation, they've been doing something for certain years, yes. Does it mean their knowledge of law, that technical aspects, etc. will be good? Yes. But does that help you in an arbitration? Not really, no. Because you can never apply a personal knowledge in an arbitration. So going back, in an ad hoc arbitration, if the parties want to make it ad hoc, fine. But put down a procedural law. What are examples of procedural law? For example, soft law such as the IBA guidelines and the taking of evidence in international arbitration. Okay. For example, the IBA guidelines is what is known as the common law world's answer. Another soft law, which was released in 2018, it's known as the inquisitorial rules of taking of evidence in international arbitration. It was the civil law world's answer to the IBA guidelines, and they're popularly called the Prague rules because it was signed and executed in Prague. And this is something to look at, because I think in the Indian context, sometimes adopting the Prague rules would be very beneficial, because the core distinction between the Prague rules and the IBA guidelines is that in the IBA guidelines, being a common law approach and system, it adopts an adversarial approach. The arbitral tribunal sits back, lets the parties sort of knock at each other's heads. Whereas in the inquisitorial system, which is a very civil law system, the arbitrators are very proactive. They will interrupt the parties during arguments. They say, no, you cannot do this, do it in this manner, X, Y, Z. It's more hands-on. And I think sometimes in the Indian context, arbitrators, unfortunately, have got very lax and very comfortable in this luxury in which they exist. That needs to change. And if parties impose that, oh, no, we want to follow the Prague rules, you put that in a clause, a tribunal is bound by that procedure, even in an ad hoc scenario. Okay? Of course, my personal preference is to avoid ad hoc arbitrations altogether and select institutional rules, because then you have certainty about all mechanisms for appointment of arbitrators when someone retires, steps down, dies, resigns the commission, is challenged, needs to be replaced, all of that. There's a fixed system in place, and it's much faster to have a institutional arbitration clause. Now, what is another term for procedural law, which should be specified in the arbitration agreement? Another term is curial law. Now, don't get confused and think, oh gosh, how will I remember curial law? Just ask yourself, just keep in mind something very simple. Look at the word itself as the answer. Curial, which means to cure. Procedural law was created to cure, to fill in the lacuna, the gap that exists in the substantive provisions. Curial law cures that gap. So the term procedural law and curial law are interchangeable. Okay, now, next, we spoke about law of the contract, proper law, substantive law. Now the law of the arbitration, also called law of the seat, which is known as lex arbitri. Okay, this is important because this governs and determines, like the seat, the provisions that govern the arbitration. Okay, I'll give you an example of each of these from an international context first, because that might make it easier to understand. Now, the juridical seat, or the lex loci arbitri, England and Wales, the law of the contract, proper law / substantive law, English law, procedural or curial law for the conduct of the arbitration. You can have, for example, the UNCITRAL rules, and also to explain what is the IBA guidelines on taking of evidence, the Prague rules, UNCITRAL rules, etc. They are what you call soft law. Okay, and the difference is soft law is not binding unless the parties specifically agree to bind themselves by. The opposite of that is hard law, which is a statute which the parties, even if they don't agree, they're still bound by that law. Now, what you could also do, okay, but again, you need to be careful if you're doing this. But some parties have done this, and my personal advice is never to do it. Some parties may want to adopt the procedural rules of a particular institution and still keep it as an ad hoc arbitration. This again goes into a pathological scenario, and I will come to that later. So never do that. Never, though you can technically speaking do so, it will create a lot of issues later on, and we'll come to those momentarily. So never do that as a rule of thumb. So the procedural curial law for the conduct of the arbitration, perhaps the UNCITRAL rules. Then you have the law of the arbitration, lex arbitri, the English Arbitration Act 96. Okay. The question that you'll ask is, can the juridical seat be different from the law of the contract, from the law of the arbitration? Yes, but it happens very rarely, and they can create severe issues of conflict between themselves. For example, if you have the law of the arbitration as being different from, let's say, the juridical seat, when a court of the seat, which has to look in supervisory jurisdiction of that arbitration, before they are able to then decide on an issue that's come before them in relation to the seat, the juridical seat, they will have to first have evidence laid on the law of the arbitration, if it belongs to if it's a different system of law other than the juridical seat. That takes more time, and it's not efficient, and again falls under the purview of a pathological clause. Okay. Now, what's important now, and this is after having covered this, and I'd like to take, please, whatever questions you have, feel free to put them in the chat window, so that in case it slips your mind or it's not immediately, you don't want to forget it, put it in the chat window, and I'm happy to address them at the end of this session. I'll make sure we leave sufficient time to do so. Okay. Now I'd like to talk very briefly, because I don't want to get into the complicated aspects of this. But I want to talk about, and in your free time, just read into it so you can see how this case law, how this concept has evolved. Okay, for your own general reading, is in 2009, the infamous, and I'm stressing on the word, the infamous decision of the Singapore Court of Appeal in Insignia Technology. This is Alstom Technology. And the 2009 is the original decision. Then you have, 2009 is the Court of Appeal decision. It was, before that, it went to the lower court in Singapore, then the Court of Appeal, then there was another decision in 2013. But look at the issue all started in 2009, where the Court of Appeal upheld a pathological clause and then other jurisdictions such as Switzerland also relying upon the infamous insignia decision, which personally I do not agree with. They enforced a pathological clause. And what was the pathological clause saying? Okay, essentially in very simple terms, it said that any and all disputes, okay, and I'm paraphrasing, any and all disputes shall be finally resolved. Okay, and carefully listen to this. Okay, I'll say this slowly. Any and all disputes shall be finally resolved by arbitration. Very clear, which this is broad enough. So far, so good, no problem. Shall be resolved by arbitration before the Singapore International Arbitration Center. Again, up to now, no issues, perfectly clear, no problem. Now here is where it gets interesting. And I'll start again. Any and all disputes shall be finally resolved by arbitration before the Singapore International Arbitration Center, which, mind you, has its own rules, in accordance with the rules of arbitration of the International Chamber of Commerce, which is the ICC rules. Then in effect, and the proceeding shall take place in Singapore and the official language shall be English. Okay? Now, the reason and the big issue that arose here was, can the Singapore International Arbitration Center administer an arbitration of another institution? The Singapore Center said yes. I mean, why wouldn't they? At the end of the day, they're getting money. The Court of Appeals said, it is technically possible, and they said yes. But I'll tell you what practical issues arose from this case, and this led to severe delay. Now, when you're having the Singapore International Center administer, which means they're coordinating with the parties, etc., but in accordance with the ICC rules. Now, under the ICC rules, one of the pillar and the cornerstone advantages, or what people consider an advantage of the ICC rules, though other institutions have this as too, but this was a USP developed by the ICC, was that all awards are scrutinized by the ICC court. Now, if this SIAC, which is the Singapore Center, is administering it, that means the Singapore Center has to coordinate with the ICC Center in Paris to schedule. So something which under the ICC rules take 2 weeks would take 4 and 5 and 6 weeks. Because having some outsider coordinate and do all of that. So you see how the difficulties and the issues that this bring. The whole idea and perspective of an arbitration is to ensure smooth and efficient progress and conduct of the arbitration, but enforcing and allowing a pathological clause to be enforced, okay, creates these issues. Now, what the ICC subsequently did when this whole drama ensued in 2012, they amended their rules to state that the ICC and the ICC rules will only apply, okay, and can only be administered by the ICC Secretariat and no one else. So they removed this issue so that there could never be such a situation ever again. Okay, that being said, there are still situations where sometimes these are administered and enforced incorrectly. So, is because there are sometimes jurisdictions which don't appreciate or understand that the fine nuances of an arbitration clause and the practical difficulties this can create. Now, in the domestic context, you may not have. There may be many arbitral institutions where you could do something like this, as long as there is no conflict. But at some point, it will cause a delay in conflict because no two rules will ever be in synchronization with each other. And I'll just give you all a quick 1 minute break because I think it's just important. I'm just going to get myself a glass of water, Johnson, if you don't mind. Just take a quick 1 minute break. Yes, apologies all. I needed a quick water break. It's rather hot today in Mumbai. I hope the weather is, of course, better in your neck of the woods. But yes, continuing from where we took a quick little break. See, when you are dealing with these situations in, let's say, the Indian context, it may be possible, for example, the Cochin rules with the Indian Council of Arbitration, but it's going to create a conflict, okay, in terms of who administers, sharing of the fees, and many other procedural aspects, because each of these rules of each institution have its own has its own mechanism in terms of replacement, appointment of arbitrators, etc. So you don't want to get into that sort of a situation, okay? Now, again, I could talk for hours and hours on this, but now I'd like to move to what I think is 50% of the battle won is in the constitution of the tribunal. 50% of your arbitration, and I'm going to repeat this till the cows come flying home, is won or lost. It's who you appoint as your arbitrator. Today, and I'm so glad that each of you, I never had these trainings, and I'm sure, I don't know, Johnson Gomez, did you have, Johnson, your time, these very practical trainings in college, which giving you a real life understanding? Were these there for you? I know they weren't for me.
No, we were also not having such kind of an professionals coming and speaking. It is always the teachers attempting to do whatever is possible within their limits.
Yeah, correct.
But
So
LGR is now trying to do something like that for the students. We are working on a project called Complete Lawyering, and this also is one of the part of the session that we are doing.
And I'm very glad, and hats off to you, Johnson, that this is exactly what the country needs, and we need this. And I want each of you here today who are attending to really appreciate the value of what you have today. You have speakers from all over coming, giving you practical advice. Now, don't think that this means your teachers are irrelevant. Your teachers are important because they give you the grounding, the foundation stone. Okay, but you need more today. You need that practical knowledge because you need to merge the foundation stone with the practical knowledge to make one cohesive unit. Okay, because see today, I never had this practical training. As Mr. Johnson Gomez said, he hasn't had to. And today, each of you must absorb and understand and appreciate from this. Today, when you go to law firms, you'll hear the senior associates, principal associates talking, or with the partners, and you'll be in the room normally taking notes, saying, "Oh, we should appoint so and so, very retired, former retired so and so, very well known retired so and so, or belonging to a certain profession which shan't be named." They should be appointed, or they, senior advocate, very well known, we should appoint them. Other than their position, do you know anything about how that arbitrator deals with procedure and an ad hoc? Have you investigated or conducted research? Do those arbitrators believe in per session fees or full day fees? Because per session is going to be a far more cost-effective, far more costly affair, which I think is ridiculous, where you have 2 sessions, 1 session, 3 sessions, whether you sit for 1 hour, 2 hours, or 15 hours, one fee. Simple. Are they going to charge hourly, lump sum, fixed fee schedule? How do they deal with issues of delay, damages, etc.? The international practices. I have been interviewed. I know someone had approached me for appointment in a arbitration seated in somewhere in Europe, and they were interviewing me to essentially see what are my ethical beliefs. Now, they will never interview me on merits, and even if someone asked me a question on merits, I would never answer that because that would be improper of me to do so. But essentially, a perspective of an interview is to see what a person believes, their ethical beliefs. Now, I'll give you one example. For me, I don't care whether we sit till 9 a.m. We start at 9 a.m. or 7 a.m. And I have sat, the longest hearing I've ever had was when we sat till 12:30 in the morning. We started at 10:15 a.m. that day, and we went on till 12:30 or 12:40 in the morning. And the parties after, 5:36, after about 7:30, 8 said, "Oh, sir, we are very tired. Will the learned arbitrator adjourn the matter for tomorrow?" I said, "Why? I am sitting here. Are you paying me extra fees to sit here?" No. It is in both the parties' interest. And the reason I did not want to adjourn it was not because I was in some great rush. Because, and in fact, if I adjourned it, I would get one more sitting fee, for one more day of hearing. But I chose not to do so because one of the witnesses, and this was the final round, final cross-examination, one of the witnesses had come from very far away, okay? And if they had stayed one more day longer than anticipated, it would have mean change the cancellation fee for changing the flights, additional day of hotel, at least additional 1 or 2 days of hotel, additional meal allowances, all of those costs would have piled up. Okay, and for me, most arbitrators couldn't care less. For me, it's unethical, unconscionable to do that. And I said, no, we're going to finish it today. And I said, if you're hungry, go, we'll order something. You can eat in front of me and argue. I have no problem. But you will finish this today. You're not going to get one more day. And we sat and they did it. This is what, though some parties and lawyers may not be used to this system, they want to take it easy. They only get hurried in when they know their money's on the line, but later they'll appreciate this. Because I remember this was many years ago, this particular case was maybe several years ago. And I remember sometime early last year, I met one of those parties, and in fact, the party who created the most fuss in that arbitration, they said, we see such a difference because of what I did of sitting that late, they didn't appoint me again in another dispute. Okay, though they had approached me, and they appointed a retired member of a certain profession, which I shan't name. And they then, and they happened to meet me, they said, oh, sir, we really wish we had appointed you. I said, why, what happened? They said, this particular arbitrator starts the hearing, they say 10:30, they only come by about 11:15, then they break for lunch by 1 o'clock. Though the lunch break is for one hour, they start only after 1.5 hours. Though the hearing is scheduled till 5 o'clock, they inevitably wrap up by 4:30, and then they'll still charge us for 2 session fees, morning, afternoon. We're losing time, money, nothing is really happening substantively, such a waste of time. I said, well, that's your cross to bear. You want something, you got to be aggressive about it, you got to push for it. And that was a learning lesson. Okay, again, 50% of your battle won or lost with who you appoint as an arbitrator. Now, we spoke about the arbitration clause, and I should have mentioned this, but I deliberately did not mention it then. It's very important to specify the language of the arbitration in the arbitration clause too. Okay? And I'll give you this, and I didn't mention this earlier, but I want to mention it now because I wanted to give an example from the perspective of who you appoint as an arbitrator and the importance of it. Okay? But today, you specify English as the language of the arbitration. Now, as some of you will learn later on, when you're enforcing an arbitral award, arbitral awards are enforceable in New York Convention signatory countries. You learn about the New York Convention in later sessions, unless it's already been covered. Which means that 2 countries who are signatory to the New York Convention, and an award passed in one will be recognized in the other, and vice versa. Now, let's take India. India is a signatory to the New York Convention. And let's take another country, Indonesia, for example. Indonesia is also a signatory to the New York Convention, which means that an award passed in India, which the winning party seeks to enforce against the losing party in Indonesia, should automatically be enforced in the Indonesian court. However, what a lot of people don't know is that the courts in Indonesia have a certain unique system, very peculiar to them, where they will recognize it. However, under their local law, under their requirements, for an award to be enforced, even if it's from a New York reciprocating territory country or New York signatory country, the award at the first instance, even if the language of the arbitration says English, the award in the first instance has to be written also in Baha'i language, which is their local language. Otherwise, and if it's not written, before you can go to the enforcement court, you'll have to first go to another local court of theirs to do the quote-unquote official translation, which can take anywhere between a few weeks to a few months. Okay, in the meantime, parties lose out on interest, and a lot of benefits, and it's a lot of money people lose out, especially on high-value contracts. Now, how could this have been solved in a situation like this? Who you appoint as your arbitrator today? If you appoint arbitrators who appreciate international cultures, who have that international experience, okay, even though they may not have acted in that particular country, but they appreciate and they understand the cultures of different jurisdictions and countries. What a good arbitrator would have done, who may not have known anything about Indonesia, ask parties, please submit. Are there any local law requirements in potential jurisdictions of enforcement? Submit. But a good arbitrator, really exceptional arbitrator, would have said, hang on, this award's potential enforcement may be in Indonesia. This award is being written in English, but simultaneously we're going to put the Baha'i language on each page and then sign it in the first instance in English and Baha'i, both, with a line saying that the English version would supervene. Then immediately the award can be enforced. Okay. Similarly, in China, I'm currently acting as a sole arbitrator in an arbitration with Chinese law as governing law, and seated in Hong Kong. And there are some aspects which, though I knew the answer, I still wanted the parties to make their submissions on it. Yeah, so that there's an official record. And this is important. Okay. Now, what's also important is an arbitrator who understands and appreciates that when a party nominates you, you are not beholden to them. You do not owe them anything at all. Your relationship with them, quote unquote, relationship ends the moment they appoint you. Okay? When parties keep saying and when lawyers keep saying, oh, this particular party is beholden to me and they are my arbitrator, they're not arbitrator, ever. They're an independent, neutral person on the tribunal. Okay? And therefore, sometimes we may ask ourselves, should we put in an arbitration clause, qualifications, etc. of an arbitrator? Yes, sometimes you may do so. Specify should be accredited and trained by XYZ Institute. Okay, should they have a certain technical requirements, etc. You can do that, but make sure you don't also make your clause so restrictive that you can't find anyone to appoint as your arbitrator. Then you have an unenforceable arbitration clause. Okay, sometimes parties may think, oh, it may be beneficial to put one person's name and both parties will agree, etc. But you can do that, but what if by the time the arbitration goes, by the time the contract goes into dispute, that arbitrator may not be conflicted, may have passed away, may be busy or unavailable to take on the appointment. Okay, so it's just important to keep that in mind too. Another consideration to keep in mind when you appoint your arbitrator, of course, is in addition to being trained, accredited, their experience. Please understand that today, if let's say you have a construction contract, or let's say you have an engineering contract, or let's say a biotech or an IP-sensitive contract, or let's say, for example, today you have an arbitration seated in Tanzania. You may think, oh, we need to get an arbitrator who's conversant only with Tanzanian law. No, that's wrong. Because please remember today, an arbitrator can never apply their own personal knowledge in an arbitration, ever. If an arbitrator is aware, being a lawyer, of some of some new case law that may affect the rights of one of the parties, which neither party has argued, an arbitrator cannot apply that case in their award. They have to call upon the parties to say, please make submissions. Are there any recent judicial developments, etc.?
Excuse me, sir.
Yes.
So sorry for interfering. Actually, we have scheduled our meeting only till 6:30, and we have a 10 minutes interactive session. So it would be nice if you could conclude it with 1 or 2 minutes.
Oh, we don't have a few more. Oh, yes, I didn't realize. My watch is a bit earlier, slow. Okay. So yes, so very briefly to sort of conclude this and wrap this part up. Of course, we can go on for hours about this concept, but please remember today, when each of you are interning at law firms or with arbitrators or sole practitioners, senior counsel, whatever, don't be shy and don't hesitate when your partner at the law firm says, oh, we'll appoint so-and-so. Yes, sir, may we ask why? Have we interviewed? No, this person is very senior. They've done this. I said, yes, but sir, don't you think, or team, don't you think we should interview this person? Don't you think we should ask them what are their views? Are they available? Can they devote sufficient time, energy, resources? Now, of course, the technical mechanisms, how you appoint under the Arbitration Act, Section 11, that's very clear. I don't need to delve into that because that you will learn in your theory. In relation to Section 15 for replacement, etc. Again, all of that is covered in the Act and you learn that in theory. But broadly speaking, this covers the importance of the constitution of the tribunal. Because also remember, a tribunal must be appropriately constituted, because there's a decision of Justice Nariman in the Supreme Court, I think February 2018, Indian Hotels, I think, if I'm not mistaken, but it's February 2018, Justice Nariman, where prior to that decision, whether Section 16, where you're challenging jurisdiction of the tribunal, there was always ambiguity whether the term jurisdiction included, in addition to what was clear in the Act, constitution or composition of the tribunal. Can that also be challenged? So can the tribunal also have jurisdiction to decide that as a jurisdictional issue? Justice Nariman, relying upon Section 30, read with Section 31 of the English Arbitration Act, said yes, composition and constitution of the tribunal is also a ground where a tribunal can rule on and falls within the purview of jurisdiction. So just have a look at that later on when you're going into the theory. So yes, I believe, Uttara, there are some questions. Are there any questions? I'd be happy to answer them.
Yes, sir. We have gotten an interactive session for 10 minutes. So the participants, if they have any doubt, they can clarify it now.
Sure, please do. Everyone, don't feel shy. Feel free to ask questions. Though I may look a little scary on the screen, don't worry. I will not fault you, because the whole idea is to learn. So feel free to ask your questions. Remember, no question is too silly. You're here to learn. No one will judge you for asking a simple question or something basic. The whole idea is to learn. So ask yourself this: would you ask a foolish question? Would you rather ask a foolish question now, or make a fool of yourself in the courtroom in front of a judge or in front of an arbitrator? This is a safe space, so feel free to ask.
Hello, sir. My name is Rajesh Kumar. I'm also participating in this program.
Good evening. Good evening, Mr. Kumar.
Yeah, good evening. I'm also from Mumbai.
Lovely.
Yeah. In fact, I'm working with a statutory body constituted under Act of Parliament.
Okay.
One doubt which I have is we are about to enter into an agreement with UNDP, United Nations Development Program.
Mm-hmm.
So what they are
like the ADB.
Yeah, like ADB. Mainly they are into development activities within India, of course, in other countries also. What is when we execute the agreement, they want to keep a clause which attracts only the international law. Okay, because being an international agency, they want to keep only international law to be applicable, and by that they want to keep a clause of arbitration which also attracts only international arbitration.
Now, when you say international law and international arbitration,
yes,
can you tell me what law and what are you referring to when you say international? Because today, just to give an explanation, today you can have an international arbitration, an international commercial arbitration in India, seated in India as well. So can you tell me, in your example, your query, your doubt, what do you mean by international law and international arbitration? If you can explain
in fact, we want to keep a clause that the Arbitration and Conciliation Act will be applicable.
Okay.
And the dispute will be settled as per the Indian Act.
Okay.
But whereas they are telling no, Indian law cannot be applicable for us, so you may have to go by international law.
Which international? But which country?
No, that they are not telling. In fact, they are working in India. Their office is here, but they don't have any activity outside in our project. So that's why.
So a very simple solution to give to them to give them that satisfaction, because their essential issue and concern, I'm assuming, would be the lack of efficiency, streamlined conduct in the Indian context. Things take too long in India, etc., etc. Correct?
Correct.
They will say, "Oh gosh, it takes too long to appoint an arbitrator. It takes too long, XYZ." Correct?
Correct.
You know, we may not agree. This person may be prejudiced, and all of those issues.
Yes,
right?
Correct. Right.
And they want the benefit of something international that, this is unfortunately a reminiscence of our British era domination. But, the simple way to answer this is tell them, okay, look, let's meet halfway. Okay.
Yeah.
You want representing this statutory body. You want the Mumbai. I'm assuming Mumbai to be the seat.
Yeah, can
The
be.
courts at Mumbai, and or some other neutral jurisdiction. Let's say, for example, if both of you are in Mumbai, so let's say for whatever mental satisfaction, if they don't want Mumbai, select another neutral jurisdiction, like let's say, for example, Chennai or Delhi. Okay.
Okay.
A neutral seat.
Yeah.
Select that as a seat. Now, to give them that international satisfaction, you can say that this arbitration will be governed by the Singapore International Arbitration Center in fact, I have done arbitrations under the International Chamber of Commerce Court of Arbitration in Paris, seated in Chennai.
Yeah.
Okay, so it's an international arbitration center, whether it be the Hong Kong Center, the ICC, SIAC, any of these major global centers. All of them will administer arbitrations while sitting in India without anyone having to travel, and all your international best practices. For example, award will be scrutinized by the ICC court overseas to check it, proofread it. All of that will be done by the international people. All of that, and one step further to satisfy them, because they want the international flavor to it. When you're preparing your arbitration clause, okay, depending on what you select, remember what I said about opt-in, opt-out provisions, because sometimes some of these statutory disputes have low value claims as well. It may not be very high. So if you anticipate it, opt out of the expedited procedure provisions and say that the parties only want 3 arbitrators and we're opting out of expedited procedure, because the default is that if it is less than a certain value, it will go to the expedited procedure under the institutional rules. Okay?
Okay.
So you put this provision and you say that each party will nominate 1 arbitrator. Okay?
Okay.
However, the presiding arbitrator will be someone who's not of an Indian nationality.
Okay.
Okay. Now, so far, though the 8th schedule was brought about under 2019 amendment, it was never implemented or given effect to. Then recently, 2 weeks ago, the 2020 ordinance for the Arbitration Act has removed that draft 8th schedule amendment. It's just added one more line saying that the Arbitration Council, which is another body yet to be formed, will decide upon what rules govern qualification of arbitrators. So as on date, there is no, just to clarify, no bar for someone who's not an Indian national to act. Or you can have someone who's not from India, who may be an Indian national, situated in Singapore, or someone from Hong Kong, a neutral jurisdiction acting as presiding. So then you're giving, so you see what you're doing, you're giving the best of both worlds. You're giving that international flavor, the domestic, and you can explain it's easier to have something domestic. They may not want Mumbai, put Delhi. Or even if that doesn't fail, another neutral venue which is close. The 2 venues which you can, 2 seats, I would suggest keep in mind. One is Singapore. Okay. Now, a lot of people prefer Dubai, but the only thing with Dubai you need to keep in mind, is if you select Dubai as the seat, any award which has Dubai as the seat, for the award to be enforceable, the award has to be signed by each arbitrator physically within the geographical location of Dubai. So when you're signing it, you cannot sign it in another country and send it. You have to be physically located in Dubai. So that's something to keep in mind if you select Dubai. Otherwise, there are excellent centers. Another place which has some very good facilities and mechanisms, even for online, if the parties select Chennai, etc., is Kazakhstan. Okay, the new IAC over there. A lot of these bodies that give you the best of both worlds. Okay, I hope that answers your query.
Yeah. Understood. Thank you, sir.
No, my pleasure. And if in case we don't, I noticed there's a question in the chat, and I'll answer that. But before that, in case we run short of time, you can't ask questions, feel free to add me on LinkedIn. I'm happy to answer those questions or clarify any doubts further. So don't hesitate. Yes, we have a question from Aishwarya. Each country has its own law. Can you explain which country's law is more? Now, Aishwarya, could you please explain to me, when you say more convenient to me, what do you mean by convenient to me? Because it is not me as an arbitrator who will find convenience. It is what the 2 parties who are signatories to that contract must decide what is beneficial for them, in terms of what type of dispute is it, how do courts, for example, some jurisdictions may be more lenient or more stringent in IP related disputes, and you need to ask yourself, would you be on the receiving end or the giving end of an IP or potential IP dispute? That's important to keep in mind. So if you can perhaps further clarify your question or ask me, I'm happy to. But it's not an arbitral tribunal decides what's more convenient. There's no one system of law that's perfect or excellent. It's just that everyone has the notion and an idea that English law is superior, etc., etc. I mean, it is good. It has certain consistency to it, but it's not. I wouldn't say it's the only or the be all and end all in terms of a system of law. India, to many respects, works really well. It's just that the players involved in the process sometimes are not efficient. Any other questions, or shall we call it a close? Like I said, with any further doubts any of you have, you can feel free to reach me on LinkedIn. Happy to answer them. Any further questions, or shall we call it a close? You're welcome, Aishwarya.
Yes, one thing that I think most of the participants was getting an exposure to actually the arbitral process from a professional point of view. And many of them might be finding it a little difficult to conceive it as such. I think that may be one issue that they may be facing there, because given the fact that I was there from the third all the sessions. Now what you need to do is you may have to read through the provisions. Statutory provisions. Most of you might not be studying Arbitration and Conciliation Act as such, but still try to read through that and get yourself acquainted with these things, so that you will come for a better understanding. In the regarding the process. We will actually need to, you need to read section 11 insofar as constitution of the arbitral tribunal is concerned. It is always said that you need to have, you can have a sole arbitrator or arbitrators of odd numbers, 1, 3, 5, and so on. How to appoint, you can specify in the agreement or such thing.
In fact, Johnson, if I may just interject and just also explain, one very interesting, and this happens very, 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 very rarely. But I was talking to an English QC a few months ago, just before the pandemic, around January, February, and he was telling me where he's acting as an arbitrator in an arbitration seated in Jakarta, Indonesia, where it is a tribunal of only 2 arbitrators. Okay, and this arbitration clause was a very strange clause, which said that each party will appoint only 1 arbitrator each. Both arbitrators need to pass a separate award, and after both awards are passed, if there is any inconsistency or any lack of consensus in their respective awards, then only on those differing issues will those 2 arbitrators have to appoint a third arbitrator as an umpire to decide only on those differing issues. Very weird and strange clause, but yes.
Very weird.
So, sorry to interrupt. Yes, go ahead. Sorry.
Yes. Therefore, these basic concepts, please get yourself acquainted when you come for the session. That is why we are announcing the what we call the titles, and minimum details are being provided. So the reading process should happen simultaneously. Here we will be discussing primarily concepts, practical points, and things like that. You will be hearing about, I think next time you will be hearing about procedural order number 1 and things like that. So you need to have a reading of part 1 of the Arbitration and Conciliation Act. That's a homework that you will have to do. Otherwise, you will will find certain concepts a little difficult to understand and digest, because most of you might not have studied that the statute as such. We don't wish to teach you, as I have said in the first session itself, we don't wish to teach you law. We will be only helping you and assisting you to interpret the law. These sessions will really help you to interpret the law. The reading process should happen simultaneously, and that's a part that you have to undertake. This is the small note that I want to point that I want to stress. We will give a detailed synopsis of the process next session beforehand, so that you may read through the provisions while you attend the sessions. That would be more helpful. And regarding the reporting, I wish you report only those facts or those ideas and concepts that are being explained. From what Mr. Anish has said, what I understood would be like one, in an arbitration agreement, that you should specify the place, you should specify or seat. He has explained the concept of place and seat and its relevance. By specifying the seat, the law, national law of the particular country where the arbitration seat is situated would apply, and the courts in that country will have jurisdiction to supervise the arbitration. He spoke also about the law of the contract, and he also specified about proper law, and he also mentioned about language, which should be specified in the contract. And broadly, he also mentioned that even when the contract is void, the arbitration clause will survive. And he also mentioned about the constitution of the arbitration tribunal.
Hello, sir.
Yes, I am concluding, don't worry, and I'm just closing. So these are the broad things that I could understand, and if necessary, you can contact Mr. Anish or raise your questions next session next week, same time when we meet. Thank you.
Thank you so much, both of you. And now that we have come to an end of our session, I now invite Ms. Devika to deliver the vote of thanks.
Thank you, Uttara. Good evening, everyone over here. Honorable guest, Mr. Anish Wadia, respected Johnson Gomez sir, Safi Mohan sir, and all the participants. It's an honor for me to have the opportunity to give a vote of thanks for today's session. I, on behalf of entire Fraternity Law and Justice Research Foundation, LGRF, Tribunal Chapter, an organization of diligent legal individuals, extends a hearty vote of thanks to Anish Wadia sir and Johnson Gomez sir for their efforts and contributions to make this event exemplary. Initially, I would like to mention deep sense of appreciation towards our most invited guest, Mr. Anish Wadia, Director of Chartered Institute of Arbitration, for his explanation and excellent coverage of the topic Arbitration Agreement and Constitutional Tribunal. It gave deep insights into the topic and also revealed interesting facts on its concepts and procedures. I'm pretty sure that the knowledge you shared with us will definitely help us in our studies and future. I'm indebted to convey my regard to you, sir. Further, I would like to acknowledge our gratitude towards Advocate Johnson Gomez, sir, Director of Cochin Institute of International Arbitration, for being with us in this session from your busy schedule and also instructing us to focus more on statutory provisions. We will definitely learn more through that. Once again, we are happy to mention Anish sir for taking time from his busy schedules, enlighten us with more knowledge through this fruitful session. And also I take this opportunity to extend my sincere gratitude to a strong pillar of LGRF, Mr. Safi Mohan sir, Assistant Professor, Government Law College, Trivandrum. Without your support and guidance, this can't be possible. Thank you so much, sir, for your guidance. And I must also appreciate the coordinating faculty, Nilima V. Nair and Advocate Sunita S. for their enormous support behind this. Finally, and most importantly, I convey my extreme gratitude to all the assets of our event who made their involvement in this wonderful session. Thank you each and everyone who supportively aided to make this session worthwhile. Thank you.
Thank you very much, Devika, for that very kind vote of thanks, and also, of course, to Mr. Johnson Gomez and each of you for attending today. I'm very grateful. Just to clarify one thing, just for the sake of propriety, I'm not a director of the India branch of FCIArb, but I'm a board member of the examination board of FCIArb in London, UK. So just wanted to clarify that. But thank you both again. Thank you, everyone, for being here on a Saturday evening when I'm sure you have more exciting things than of course, to sit and hear a man with graying hairs talk. But very nice to have each of you here today. And again, like Mr. Johnson Gomez has said, please feel free to reach out to me on LinkedIn if you have any questions and queries. And all the best for your respective careers. Thank you very much.
It's actually our pleasure to have you with us today, sir.
Thank you.
Now that we have officially come to an end of our today's session, and now I declare our sessions officially over.
Thank you.
Thank you so much, sir.